Good morning. You're very welcome to our webinar on the Assisted Decision-Making Capacity Act. We've had a huge response and a huge level of interest with 180 people registered to attend the webinar today. For those of you who don't know me, I'm Cliona Murphy and I'm the Professional Development Coordinator with the Irish Association of Social Workers. You mightn't have had a chance to look at the agenda yet on the event platform. So I'll just run through that very quickly before we start today. First up, we have Jacqueline Grogan from the HSE, who'll be giving us an overview of the Act. Then we're going to hear from Marie Tighe from the HSE, who will speak about the HSE National Consent Policy. Next up is Patricia Rickard-Clark, who'll talk about place of care decisions and protection of liberty safeguards. And then Amanda Casey, Head Social Worker in the Mater Hospital, will speak then of the implications of the Act for social work and reflect on some of those practice decisions that are coming up in an acute hospital. If you'd like to ask a question to our panel, I'd ask you to put that question into the Q&A. Feel free to enter your comments into the chat. If you'd like to have a little look around the online platform as well, you'll see that you can chat to other attendees and send them messages as well. You might also want to look at the speaker biographies in more detail, so feel free to have a look around as you're listening. If you're going to tweet today, I'd ask you to use the hashtags, hashtag ADM, hashtag My Voice, My Decision, and Residents Have Rights hashtag as well. First up then, I'm going to hand over to Jacqueline Grogan from the HSE. And just to tell you a little bit about Jacqueline, she's the project manager in the National Office for Human Rights and Equality Policy, and she's responsible for the Assisted Decision-Making Capacity Act, wardship, public sector duty, transgender and intersex issues, and universal access. So without further ado, I'll hand over to Jacqueline.
Thanks, Cliona, and good morning, everybody. And thank you for taking the time to join us today. Just to tell you a little bit about myself. I'm Jacqueline Grogan. I'm the project manager in the National Office for Human Rights and Equality Policy, as Cliona said. Our office has a wide-ranging remit covering all the areas that Cliona mentioned, but we also have we kind of manage the HSE National Consent Policy. We do stuff around DNAR as well, and Marie leads out on that side of things. So I'm going to talk to you today about the Assisted Decision-Making Capacity Act. I'm going to give you an overview of the Act and talk about the guiding principles of the Act as well. But what I'm going to do first is I'm going to show you a short explainer video that our office developed last year, which we've launched, which is about kind of what's included in the Act, but also kind of gives you kind of what people's views are on the Act and why the Act matters to them. So we're going to show this short video for you now. Thanks.
We all make decisions, big and small, every day of our lives. Most of us are able to make these decisions by ourselves. There are many people accessing our health services whose ability to make certain decisions about their life and choices may be affected by a disability, an accident, a medical procedure, or a chronic illness, either on a temporary or permanent basis. A new law called the Assisted Decision-Making Capacity Act 2015 has been passed, which gives people the right to be assisted to make decisions with legally recognised supports regardless of disability or any condition which may affect their decision-making capacity. The Act is for everyone over the age of 18 who has difficulty now or who might in the future have difficulty making decisions. A number of decisions are covered by the Act, including day-to-day decisions, what to eat and what to wear, through to more complex decisions like whether to buy or sell a house or to have a surgical procedure or what to do with a large sum of money. All services are covered by the Act: banking and financial services, legal services, and health and social care. A number of key features of the Act include: a person has capacity until proved otherwise. A person should be supported to make decisions as far as possible. Information should be provided to a person in a way that is easily accessible. A person has the right to make an unwise decision if they choose to. A person can make an advanced decision about their healthcare treatment, which will apply when she or he can no longer make those decisions. The wards of court system will be abolished and a new system will be put in place. A new body called the Decision Support Service has been set up to oversee the Act and is based in the Mental Health Commission. The Decision Support Service has a number of functions, including public awareness of the Act and supervision of the decision-making support arrangements.
The Act puts me in charge of my life. It means I can get to make decisions when I want it. This Act is great because this is my life and I have the same voice as everyone.
This Act matters to me as Damien's mum because it makes it clear that Damien has the right to make his own decisions, which is really important. It also means that we can get information and advice that he might need to support him in his decision making now and in the future. The Act also provides reassurance for me that when I'm not with Damien, that he'll be able to get appropriate support to make decisions in relation to all aspects of his life, but that his right to make his own decisions will be safeguarded.
I'm currently making my wishes and preferences known to my husband and sons. If I suffer a serious illness or there is an emergency which affects my ability to communicate, my family will know what I would want, and with this knowledge will be able to support me while at the same time making sure that my rights as a human being are respected.
This new Act encourages us to plan and think ahead, which is so important for us all. The Act will allow me to be legally recognised as Veronica's support person.
The Act allows people to plan ahead and put in place legal binding arrangements about the healthcare treatment they do not want when they no longer have the capacity to make this decision.
This Act matters to me because I will be able to support individuals that I work with to make their own choices in life and to be more involved in what happens to them.
This Act matters to me as a dentist. It is important that the patients I treat have a full understanding of their dental care and treatment options, and that they are supported and enabled to make decisions in relation to their own oral health.
The Acts that matter to me because I won't lose all my rights to make my own decision, which is what can happen if a person is made a ward of court. Even if I can't make my own decisions, the Act keeps my wishes and values and beliefs at the centre. There can be no decision about me without me.
Assumptions should not be made about a person's ability to make and communicate decisions based on an initial diagnosis, especially in the case of a severe acquired brain injury, where the condition of the person can improve over time.
Pádraig enjoys life, and a big part of that is being able to make decisions and to let us know what he wants. These decisions range from basic day-to-day decisions, what he wants to eat, what he wants to watch on TV, to more complex decisions about care and treatment. And sometimes Pádraig's decisions surprise us.
I represent public health and community nursing services. We as nurses hold a very privileged position of entering into people's homes and of witnessing the reality of how patients live their lives. Therefore, I wholeheartedly embrace the opportunities that the Act will bring for patients to shape their healthcare decisions. The Act provides an opportunity for patients to have a voice and represents an approach which appreciates the values, needs and preferences of each and every patient. This is achieved when patients are facilitated to become informed decision makers and exercise their choice in a shared decision-making process.
The Act provides legislation for advanced healthcare directives. This is where a statement is made by a person with capacity setting out his or her will and preferences about medical treatment which may arise in the future at a time when they no longer have the capacity to make decisions. It will guide the treating doctor to care for the patient in a way that the patient would have wanted, and I believe that will be very helpful in general practice. The area that it will have huge relevance will be transferring persons from nursing homes to acute hospitals who do not have the capacity to say no.
Why this Act matters to me. If my mental health deteriorates, I lack the capacity to make decisions for myself. I nominate my husband Pádraig to act on my behalf in carrying out my decisions and wishes if I'm unable to do it myself.
And this Act means that Margaret, the person I love and support, will feel happier and empowered if her wishes are both respected and listened to.
This Act means that the people in my care can be assured that they have the right to access information in a way that can maximise their understanding, and they are to be given more time to understand that information, to help them to make decisions.
The Act recognises that people need formal supporters to help them make decisions. These formal supporters are called interveners. A person can have a number of supporters to assist them with different decisions.
Nothing about me without me.
Nothing about me without me.
Nothing about me without me.
Nothing about Pádraig without Pádraig. Do you agree with that, Pádraig? Yes.
I hope you enjoyed the video. Just to say that video is available on our website, www.assisteddecisionmaking.ie, and so is the recording of the launch of the video that we did back in September last year as well. So you're more than welcome to watch that and share that with your colleagues. And I think actually Cliona put the information for it up onto the IASW website in advance of today. So I'm just going to go into a little bit more detail now about the Act, because as you can see, that was a very kind of brief overview of what's contained within the Act. But I do think that the personal stories that people share are so powerful in the terms of kind of helping people understand what the Act's actually going to mean for people in practice. So the Act itself is described as an Act to provide for the reform of the law relating to persons who require or may require assistance in exercising their decision-making capacity, whether immediately or in the future. And it was signed into law by the President on the 30th of December 2015. And only some sections of the Act have commenced. So the part to establish the Decision Support Services commenced, the part to appoint the Director of the Decision Support Service, and the section to establish the Multidisciplinary Working Group on Advanced Healthcare Directives. And actually only recently one other part of the Act was commenced, which was the part that abolishes the 1811 Marriage of Lunatics Act. So, I mean, that's a huge change. The fact that we had a piece of legislation that was still being implemented from 1811 on our statute books is phenomenal in so many ways. And the fact that that's now been abolished is a huge step in order for Ireland to kind of meet its commitments under the UNCRPD. So who's the legislation for? It's restricted to people who are aged 18 years or over, and in particular applies to people whose decision-making capacity is being called into question, may shortly be called into question, or who lack capacity in respect of one or more than one matter. So, but when you think about the numbers, there's about 64,000 people in Ireland at the moment living with dementia, and the estimate that's going to be about 141,000 by 2050. There's about 10,000 people who have a traumatic brain injury every year. There's over 66,000 people living in Ireland with an intellectual disability. 1 in 4 people who have a mental health condition. The numbers of people that may require the support of this Act at some point in their lifetime is huge. And actually, as part of their work while they were scoping out the establishment of the Decision Support Service, the Decision Support Service did some work, and they estimate that about 220,000 adults may have an arrangement with the DSS at any one time. They reckon 1 in 20 adults will have an active arrangement, and that 1 in 2 of us will come in contact with the Decision Support Service in our lifetime. So, I mean, this Act is going to impact on an incredibly large amount of people who are in our population. So what does the Act actually say? The Act requires service providers to provide a range of supports and information to help a person to make a decision. And I think at this point it's really important to realise that the capacity part of the Act is in brackets for a reason. The whole ethos of the Act is around assisting and supporting people to make a decision. And there's a number of things that you need to do before you even go down the route of assessing somebody's capacity to make that decision. And I also think it's important to remember that the Act is what's called a disability neutral Act. So unlike the Mental Capacity Act in England and Wales, there isn't a diagnostic test in this Act. So it doesn't matter what condition you have, or you might not have a condition at all. This Act can still be impactful for you. And the Act, it's also important to remember that all of us need support at some time when we're making decisions, and that in certain times and in certain situations, some people might need a little bit more support than others. And if you think about kind of complex decisions that you've made recently, the chances are that you've gone to your friends, your family members for support to help you make that decision. So we all need support at some times around our decision making. Built within the Act, there are a number of guiding principles. Now, an awful lot of these we already do in our day-to-day practice. There's some that we could maybe do a little bit better. And I think it's important to kind of remember that before we get to that capacity stage, we need to be looking at, have we done all of the guiding principles? So the first guiding principle is a presumption of capacity. So it's presumed that the person has capacity to make their own decision unless it's proved otherwise. And this just re-emphasizes to us that every adult has the right to make their own decisions, and that they have to be supported and presumed that they can make these decisions unless it's proved otherwise. And a lack of capacity should not be automatically assumed simply because of a person's age, a diagnosis, a particular behavior, or their appearance. And similarly, just because somebody's lacked capacity to make a previous decision, it doesn't necessarily mean that they can't make that decision that's currently in question. So just because I lack capacity to make a decision maybe about my finances doesn't mean that I lack capacity to decide where I want to live or what I want to do on a day-to-day basis. The next guiding principle is support to make a decision. So everybody has a right to be supported to make decisions. And that means that all practical steps need to be taken to help the person make the decision themselves before they're being treated as unable to make that particular decision. In practice, that means it's kind of important to consider how and when the person is being asked to make the decision. Is there a particular time of day that they're more alert, that they might be better at making that particular decision? What the most appropriate way to communicate with them is? Have they been given all of the relevant information in a format that they can understand? Is the location that you're asking them to make that decision having an effect? Do they need assistance from someone else? Because an awful lot of time we can wrongly presume that somebody doesn't have the capacity simply because we haven't given the time or the effort or the appropriate information to them in a format that they can understand. The next guiding principle is around unwise decisions. And I know this one causes concern in services everywhere and with a large amount of people. And myself and Marie would have spoken to probably close to 20,000 people about the Act at this stage. And this is the one that always gets the conversation going. So the Act says that a person cannot be considered as being unable to make a decision merely because they have made or are likely to make a decision that we see as being unwise. So people have the right to make decisions that others might regard as being unwise or eccentric, and you can't treat somebody as lacking capacity purely for this reason. Everyone has their own values, their own beliefs and preferences, and they might not be the same as what other people have. So just because they're making that decision that's unwise doesn't mean that they lack the capacity. So that when you're looking at somebody's capacity, and I'll talk about the functional approach in a minute, you have to look at it needs to be based on how the person has made that decision as opposed to what the potential outcome of that decision might be. The Act also says that person has a right to have accessible information in relation to that particular decision. They're allowed more time to understand it, and they're allowed that information in a range of different formats to maximise their understanding, like easy to read, audio, video, text, pictures. And this is already legislated for in things like the Disability Act and the Equal Status Act. But I think the question we need to ask ourselves is, do we routinely do this? And how do we make sure that we give people enough time to understand the information when we work in settings that can traditionally be seen as being time poor? So do we put pressure on people to make the decision at a time that's more suitable for us, as opposed to a time that's most suitable for the person? The Act also provides for what are called interveners, and their role is to support the person to maximise their decision-making capacity, and I'll come back to them in a second. Another next guiding principle is retention for short periods. So the ability to retain information for a short period only does not mean that the person lacks capacity to make that decision. So in order for them to make their own decision, the person needs to be able to demonstrate that they can retain the information long enough to make that decision, but there's no requirement for them to retain the information for longer than that. So things like notebooks and prompt sheets and things can be used to record information, which might help the person to retain the information when you come back to them at a later time. The last guiding principle is around the least restrictive intervention, and this basically says that there shouldn't be an intervention unless it's necessary to do so, and any intervention has to be in a manner that minimises any restrictions on the person's rights and freedom of action. It has to be as limited in duration as possible. It needs to be proportionate to the significance and the urgency of the decision, and it has to be for the benefit of the person. This Act doesn't talk about best interests. This Act talks about acting in the person's will and acting in the person for the benefit of the person. Which is a slightly different approach to kind of thinking about how we work with someone. So if somebody's making a decision, or if you're acting on behalf of somebody that you might think lacks capacity, it's important to think about what's going to interfere the least with the person's rights and freedom of action. And the other thing is whether you actually need to intervene at all. So any intervention does need to be weighed up in the particular circumstances of that particular decision. The Act has a definition of capacity. So the capacity in the Act is defined as a person's ability to understand, at the time a decision is to be made, the nature and the consequences of the decision in the context of the available choices at that time. So as you can see, it's quite a nuanced definition of capacity. It's all about a particular decision at a particular time with the particular choices that happen to be available at that moment. So we're moving from how we've traditionally worked, where we've maybe gone with a status approach, which is because you have a condition, a diagnosis of an intellectual disability or dementia, you lack capacity to make decisions. And that outcome approach to capacity, which is that whole thing about what you want to do is so unwise that you must lack capacity to do it, to what's called a functional approach to capacity, which focuses on how the decision is made and not the outcome or consequence of the decision. And the functional approach is issue specific, context specific, and time specific. So as I said, it's about, can Jacqueline make a decision about her finances at this particular moment in time? And if it's not an urgent decision that needs to be made, maybe Jacqueline will be better making this decision in the evening, because that's when she's better at making decisions, and allowing for that flexibility and that kind of fluctuating capacity piece, where some people might be better at making some decisions at certain times of day than at others. Built into the Act, there's a functional assessment of capacity, and the functional assessment basically says that a person is unable to make a decision for themselves if they're unable to understand the information in relation to the decision, if they're unable to retain the information for long enough to make a choice, if they're unable to use or weigh up that information as part of the process of making the decision, and if they're unable to communicate their decision, whether by talking, sign language, or any other means. And if you're unable to do any one of those 4 items, then it's determined that you lack capacity to make that particular decision. But it's really important to remember that in order, before you get to the functional assessment of capacity, you need to have done everything that you possibly can with those guiding principles. So you need to be giving people the information in order to help them understand the information. You need to be giving them the prompts, the notebooks with the information in it to help them to retain the information. You need to be giving them all the pros and cons so that they can use and weigh up that information. And I think when you're using and weighing up, it's important to remember that just because somebody's weighing up that information in a different way than you would doesn't necessarily mean that they lack capacity to make that decision as well. And they also need to be given all the support to communicate that decision. So the capacity assessment comes as kind of the last kind of point of call. You need to be doing all of everything that's built within the guiding principles before you get there. The Act talks about a person's will and preference. So as I said, it's kind of moving away from that best interests approach. So if there's a concern that somebody lacks capacity to make a decision, it's essential that their past will and preference is taken into consideration. So you need to consider what they would have wanted to happen before they lack capacity and what their beliefs and values are. But I think kind of when we're talking about will and preference and capacity, one of the big questions that comes back again to that unwise decision is what happens when will and preference is no longer safe? What happens when you have the woman who wants to be discharged from hospital, but you think that she might have an accident and kind of fall on the floor? What happens when you've got somebody who's wanting to kind of go on a different kind of holiday that you don't necessarily think is appropriate for them? And I suppose for disability services, who I would have worked with in the past, this is a huge issue when it comes to risk and unwise decision. If this is the person's will and preference, what do you do? What do you do? And how do you work with that person? Under the Act, the ward of court system will be abolished. All existing wards will be reviewed. They'll be discharged fully from wardship, and they'll be supported to transition into one or more than one of the new decision-making arrangements that are provided for under the Act. So the big shift with this is that the new support arrangements are about specific decisions, unlike wardship, which is that blankets all decisions. The new decision-making support arrangements are much more nuanced, and I'll talk about them in a second. Under the Act, all wards of court have to be reviewed within 3 years of the Act being commenced. So there's just under 3,000 wards of court in Ireland at the moment. So that review piece is going to be a big piece of work for the court system when the Act gets commenced. Under the Act, there's a number of legally recognised persons. So the first person is, in the lowest level of support, is what's called a decision-making assistant, and they're appointed by the person. And so I would decide who I want to be my decision-making assistant, and their role is maybe to help me obtain the information that I need, explain the information, or communicate my decision. The decision-making at the end of the day is still the person's responsibility. So I would still be making my own decision. I just need that little bit of support in order to make it. The next stage up is a co-decision maker. So the person can appoint their own co-decision maker. And the difference with this one is that they make decisions jointly under what's called a co-decision making agreement. The decision making is shared jointly between the person and the co-decision maker, and the co-decision maker is supervised by the director of the decision support service. Because I'm now losing my autonomy slightly, there's a bit of oversight with this one. So there needs to be a statement sent to the director of the decision support service by a healthcare professional medical professional and another healthcare professional to say that I require the support of a co-decision maker, that I wouldn't be able to make the decision with a decision-making assistant, and that I don't need the support of a decision-making representative. The highest level of support then is a decision-making representative, and that's kind of like your last resort. So hopefully this is for a small minority of people who are unable to make decisions, even with the help that the Act provides for. So the Circuit Court has a role around this in appointing a decision-making representative, and they make decisions. The decision-making representative will make decisions on the person's behalf, but they must abide by the guiding principles within the Act, and they have to reflect the person's will and preference where possible. So the functions of decision-making representative will be limited in scope and duration. So they might have the authority to make decisions around my financial decisions, but they may not have the authority to make decisions about my healthcare treatment choices. And it's going to be important that staff members are clear if somebody comes in and says, I'm Jacqueline's decision-making representative, exactly what the scope of that decision-making representation order is. And they're supervised as well by the director of the decision support service. Now, one of the big questions that we get from an awful lot of people when we go out and we talk, and I think if any of you were on the decision support service event a couple of days ago, one of the big things is that we've had family members who have been doing this role for years, where they haven't been questioned, and we get lots of questions about, so you now saying that I have to go to court in order for me to become my loved one's decision-making representative, and that's going to be a big hurdle to kind of come across. We're going to have to work very closely with families to help get them ready for the commencement of the Act. The Act also allows for a change in the enduring power of attorney service. So that's where a donor who's the person who may lack capacity in the future, gives general power to an attorney to act on their behalf when they lack capacity. A big change with this is there'll be much more oversight around enduring power of attorney. So if you think that the attorney is unsuitable, if you think there's been fraud or undue pressure, then an objection can be made to the director of the Decision Support Service to let them know, and they have investigative powers, and actually there can be criminal sanctions around that as well. The Act also allows for advanced healthcare directives, which is a legally recognised statement about what your future medical or surgical treatment choices are. And again, it comes into effect when you lack capacity. So you write your advanced healthcare directive when you have capacity for a time when you lack capacity. So every one of us in this Zoom room could go out and write our advanced healthcare directive tomorrow. Under your Advanced Healthcare Directive, you can refuse medical treatment in advance. That part is legally binding. You can also request medical treatment in advance. That part is not legally binding because you might be requesting something that's contraindicative or that isn't available in the state, but it has to be taken into consideration by your clinician as what it is your will and preference. Your directive has to be in writing, signed and witnessed, and in your Advanced Healthcare Directive, you can appoint what's called a designated healthcare representative, and their role is to ensure that the terms of your Advanced Healthcare Directive are adhered to. And they have a role in terms of that interpretation piece, and they can consent and refuse to treatment up to and including life-sustaining treatment. Your designated healthcare representative has to keep a written record of all decisions made because you may regain capacity. So I know of a number of people who I've worked with in the past who have advanced healthcare directives purely around their mental health treatment choices because they know that when they're in crisis, they can't make those decisions. So they would want to know what decisions were made when they lacked capacity at that particular point in time. But as a country, we have a really poor instance of planning ahead. So a lot of us would have a will, but which is great, but obviously your will is for when you die. People don't put things in place for when they're still alive. So this was a survey that was done by Safeguarding Ireland, where they found that there's only 7% of people who actually know what the Think Ahead guide is, and it's actually a really good basis for you to start those thinking and that planning around what you would want to happen in your future. Only 11% know what an advanced healthcare directive is, so there's a need for kind of a public awareness campaign around the area of planning ahead for your future, because while you may not have capacity in certain areas, you're still living and you still want to have a life. So I think it's really important that we start thinking about what do we want to happen when we get to that point. And I think that Patricia, who's on this, she's very strong views around this, and she might talk about them a little bit when she's talking about place of care. So in summary, when you have capacity, you can put plans in place for the future. So you can put in place your enduring power of attorney and your advanced healthcare directive. If your capacities in question or may shortly be called into question, it's your decision-making assistance agreement and your co-decision making. And if you lack capacity in your enduring power of attorney or your advanced healthcare directive doesn't include that decision, it's a decision-making representation order. So they're your interveners that are built into the Act. So I think I'm going to very quickly talk about where we are now. So as I said at the start, the Decision Support Service has been established and they're based within the Mental Health Commission. Anya Flynn is the director of the Decision Support Service, and she's come from a background of human rights law. She would have done an awful lot of work with wards of court, so she's really well placed at getting this service up and running. But the Decision Support Service has a huge number of functions, including promotion of of awareness and confidence of the framework, registers of the arrangements, to supervise the decision support arrangements. So they have a massive role. At the moment, they have 17 draft codes of practice. In those 17 draft codes of practice, that covers a multitude of areas, including all the decision-making arrangements, kind of looking at assessing capacity and supporting decision-making. 4 of those codes of practice would have been drafted by our office and the Multidisciplinary Working Group on Advanced Healthcare Directives. So we've got one, which is an overarching code on what the Act means for health and social care. and 3 codes of practice around advanced healthcare directives, and they're all with the Decision Support Service for their consideration. And there'll be a national consultation on all 17 codes of practice probably later this year in order to kind of get everything ready. They have a public information campaign, and you would have seen, if any of you were on the event 2 days ago, they launched their explainer video, which isn't on their website yet. I did check before I came on, but I can certainly let Cleona know when it is available on their website, because it's a really good explainer video about the role and the function of the Decision Support Service. And just to say that the Act is due to be commenced in June 2022. So we don't have long in terms of getting ready for the Act being commenced. I know we've had 5 years up until now, but really kind of the push is on in order to get services ready for commencement. In terms of our office, our role is around supporting yourselves for frontline services. As I said, we drafted the codes of practice. We're currently developing a number of e-learning programs. The first lot will be available hopefully later this year on supporting decision-making, advanced care planning, and the functional approach to capacity. And then there's 3 more on the Act, on the interveners, and advanced healthcare directives, which will hopefully be available later this year, early next year. We've been doing a number of webinars around the Act and kind of different aspects of the Act and consent, all of which have been recorded and are available on our website, which is there. We have a newsletter. If you're wanting to be signed up to our newsletter, please email us on adm@hse.ie and we will add us to our mailing list. But I think what is really important is that now is a time for change. We're now looking at kind of changing the kind of a recalibration of rights in some way, where we're very much supporting people's autonomy and allowing them that kind of ability to exercise their capacity and their legal capacity. But I think the biggest thing for me particularly is the whole concept of nothing about me without me. For years, we've been making decisions about people without them having an input into their decisions, and this Act is going to change all of that. In terms of my final thoughts, I think this quote by Beamer and Brooks is really powerful. So it says that the starting point is not a test of capacity, but the presumption that every human being is communicating all of the time, and that this communication will include preferences. Preferences can be built up into expressions of choice and these into formal decisions. And from this perspective, where someone lands in a continuum of capacity is not half as important as the amount and type of support that they get to build those preferences into choices. As I said at the start, the capacity piece is secondary. We need to be supporting the people in the first instance in order to help them to make their own decisions. Our contact information is at the end of the slides, which we'll share with you at the end. And thank you very much for your time.
Thank you, Jacqueline. I think I was really very struck there about, I suppose it's an act for everybody, and the stat that half of all adults will come into contact with the Decision Support Service is really striking, with 1 in 20 having an active arrangement that that's going to happen. It really is something that supports all of us in our decision making, and the idea that service providers will provide a range of supports and information to support all of us when we need to make decisions and we need that assistance and support came through very clearly. And if I can just also say thank you, Jacqueline, for the clearest explanation of the functional approach that I've heard to date. Thank you for that. I'd like to hand over now to Marie Tyke, who's a project manager in the same office as Jacqueline Grogan, the HSE Office for Human Rights and Equality Policy. Marie's areas of responsibility include revision and oversight of the HSE National Consent Policy, the Do Not Attempt to Resuscitate Policy, advanced care planning, and advanced healthcare directives. So I'll hand over to Marie now.
Thank you very much, Cleona, for that lovely introduction, and thank you, Jacqueline, for your presentation in relation to being very informative and setting the platform for me, because a lot of the concepts that I'll talk about all relate back to decision making and to the functional approach to capacity. It's all about information, having enough information, and then making a decision based on that information. And just before I start, if I'm not sure if many of you tuned in to some of the webinars we ran during the vaccination program. They are, again, on our website on assisted decision making. So if you get an opportunity, they are very informative. Some of the questions and answers are really kind of, I suppose, they set the basis for all decisions, regardless of whether it's vaccination or not. But it has been very beneficial, we believe anyway, and the feedback has been very positive on it. So then in relation to consent, what we found was when we were doing talks around the Act, that consent was an integral part of it. It was a core component of decision making, and it was all about, you know, persons' rights. So where have the principles of consent originated from? Well, they're a fundamental principle in ethics. They're about being human and worthy of respect. So all of us expect that before something is done to us, that we get permission to do it, and that the person has a right to refuse as well as to agree to it. So it's all about a person's actions and decisions, that they're your own, and that other people should respect them. But it's also about a person's right to control their own life and to decide what happens to their own body. And that's where you see bodily integrity. And that's in our Constitution. It's all about a person making informed decisions about the care that they receive, or the treatment or service or whatever it is that they're about to engage on. But it's also about us as healthcare professionals respecting a person's right to consent or indeed to refuse treatment. And we know now we also have the Irish Human Rights and Equality Commission, and their role is to promote and protect human rights and equality. And it's about building a culture of respect. And we see now more and more that the Irish Human Rights and Equality Commission are becoming involved in a lot more human rights issues. And when Patricia will talk later about deprivation of liberty, we will see that they were part of contributing to that case, the Cork case, as we refer to it. So what is consent? Well, a basic definition of consent is given in the consent policy. It's about getting permission or an agreement for an intervention, receipt or use of a health and social care service, or participating in research, but it's about following a process of communication about the proposed intervention. So really, in essence, in summary, it's about a person's ability to be able to say yes or no to something. So what is informed consent? And again, it's always going back to the process of clear communication about what's going to happen. It's not about a signature on a form, and you will see that in healthcare we have become obsessed with having a signature on a form, and that the consent form only exists to document that the person has been provided with information and that they have understood that information and they have agreed to be part of the intervention. So the signature is only really a documentation that a conversation has taken place. So what is valid and informed consent? So when people are given information, how much information do they need to get? How is the information presented to them? And are they in a position to make an informed choice as a result of that information? So that's just a slide showing that no information should be presented in such a way that a person is trying to go round in rings, trying to find out what is the best option for them. So what's valid informed consent then? Well, it's important that information is given in a manner that the reasonable person can understand. It's also important that the decision is made voluntary, that there is no duress or coercion for the person, that they're not being forced into making a decision. And it's important that they understand that they have a choice and that they have decision-making capacity, but bearing in mind that the presumption of capacity is your starting point, and that a person shouldn't have to prove that they have capacity in order to be able to make a decision. And that's in relation to any decision that a person makes. So then what information does a person need to get? Well, they need to get enough of it in the first place, but it also needs to be adapted to the particular person. And again, it's about the reasonable person and what they would expect to know. So if it's about a treatment or a diagnosis or whatever, it's ensuring that they have enough information around that and including any uncertainties And you'll see in certain areas, particularly in cancer diagnosis, where you have a multidisciplinary team, that sometimes, and most of the time, that it's done very well in those situations, and in other situations, it's not always that clear. But it's also about the person having the option for treating or managing that condition, including the options not to treat. And that's about the various options that might be available to them. And that the purpose of any proposed intervention and what it will involve. So it's looking at potential benefits, risks, and the likelihood of success of a proposed intervention, as well as that of any available alternatives. So you're looking at the likelihood intervention, will it be successful? What are the risks of doing nothing or taking an alternative approach? Are the costs involved? What are the common, if minor, side effects or complications? And what are the rare but serious outcomes, death, permanent disability, etc.? But it's also helpful to put those risks into perspective. So you need to know whether it's a 1 in 5 chance, 1 in 100 chance, or whatever. And whether the proposed intervention or investigation is part of a research project. So it's important that they're made aware of all of those choices that they have. So in summary, informed consent is about explaining the benefits, harms, and risks, including all the options, including doing nothing. The person themselves must remain neutral, that's giving the information, but that doesn't mean that they can't recommend something. They must acknowledge any uncertainties that are there. They need to be able to specify the duration of the various aspects. They need to be complete in the information that they're given. And they need to avoid subjectivity. And they need to present information in more than one way. And that's about 1 in 5 or 5 in 6 or whatever, so that a person can understand it and what's relevant to that person. And I suppose it's important when you're looking at risks and benefits that it's put in perspective for a different person, and you're looking at things like the jobs that they actually do. Do they hold on a job? Because it might be important that if they are to lose a finger, a hand, or whatever, or have a disability as a result of that particular intervention, that it's put in perspective in relation to that person's life. When should you get consent? And this is oftentimes very topical, because sometimes you see a person might be seen in outpatients 2 years before they actually have a procedure, or before they see another person again. So it's important to bear in mind, consent is what Jacqueline talked about, being on the continuum of continuous communication. So it's about a continuous process of communication, and that's bearing in mind that some people's conditions or interventions may change over time, and there's lots of aspects that change in a period of time, particularly if it's a long period from when the person has had their first contact with the service. So ideally, it should always be got well in advance. And even if it's got well in advance, you then need to check with the person when it becomes closer to the time. So you need to confirm with people as well, even though you might not have got consent about a week or 2 weeks, 3 weeks, 6 months, 2 years ago. You need to kind of confirm with them, are they happy to go ahead? Do they understand the information? Because lots of people now are getting information from lots of sources, and in particular the internet. And you need to make sure that they don't have conflicting information or got misinformation, because they all talk to our friends, we all do, when we're confronted with situations. And it's important to make sure that they're not confused, that the information that they have is correct. So the person may also need clarity of treatment, particularly complex treatment that's been provided in various stages. And there may be changes along the continuum of treatment. So they need to be made aware of the various changes that are happening, why they're happening, and what this means for them. And if there is different professions involved in different aspects of their care, they also need to get consent for the aspects of care that they're involved in. And they also are, I suppose, unexpected issues arise during interventions, and a person may need clarity, and they may not always be in a position to speak up for themselves. So what do you do then if a person declines information? Well, that should be respected as far as possible, but you need to give them some basic information, and particularly if there's a major intervention involved. And if a person refuses to receive information, you need to document that about their condition. But it's important also to bear in mind that if a person might get upset or might refuse treatment as a result of receiving information, that's not a valid reason for withholding information that they may need or that they're entitled to know about their treatment or the condition, because it may affect their decision making in relation to it. So in emergency situations then, in life-threatening situations where a person lacks capacity, the urgency of the situation may make it impossible to have a conversation. So in those situations, treatment may be administered, but that's very limited to situations where the treatment is immediately necessary to save the life of a person or the health of a person. When should you not get consent? Well, you shouldn't get consent just before a procedure is about to start. And you'll see, is it the Fitzpatrick case versus White, where a person was approached, went into the operating theatre to get consent, but that consent should have been gotten way in advance. You shouldn't get consent if a person is sedated, if they're in pain, or if they're extremely anxious. Who should get consent? Well, the person providing the health and social care service or intervention should be the person getting consent. On occasions, it may be delegated to another suitably trained or qualified person that has sufficient knowledge of the procedure and of the person and the various aspects of the treatment. And if there's different aspects of care being provided by different people, each should usually get consent for that particular intervention. How should it be documented? Well, it needs to be clearly documented in the person's record. And that what needs to be documented is a record of the exact conversation that has taken place. And that is really important, because if ever a case goes to court, that is normally what's taken into consideration is what has been written down in the person's record. So what you need to write down then is about the intervention, and particularly if it's very invasive or complex procedure and if there's significant risks involved. So you need to outline all of that in the healthcare record. And you also need to document if there is significant consequences for employment or social or personal life after a procedure, that all of those issues have been discussed and what exactly the person has agreed to. So the agreement can be documented by a signature or mark on a consent form, or through you can document their verbal consent in a healthcare record. The consent form exists only to document that the person has had the information, has understood the information, and has agreed to the particular intervention. The consent form is not proof that an adequate form of communication has occurred or that the consent is valid. So that's really important to bear in mind, given that we put such an emphasis on the consent form and rarely check a healthcare record in relation to what has been documented. Who can consent? Well, all people have the right to make decisions and choice about their own lives. So all of us have the right to consent. Every adult person is presumed to have the decision-making capacity to decide whether they can consent or refuse, unless the contrary is shown. And a person doesn't have to prove that they have capacity to make a decision. However, what is the role of next of kin? Well, I suppose there's a false belief amongst staff and indeed the general public in relation to the authority that next of kin have. And if I was to ask any of you now, who's your next of kin? Who would you tell me they are? Is it your husband, wife, partner, son, daughter, mother, father? Who exactly is it? Yet everywhere we go, and particularly in healthcare, what's the first question you're asked? It's nearly always, who's your next of kin? This is a study that SAGE did in relation to looking at the role of next of kin, and this was done with the general public. And this is, I suppose, the problem that we're actually dealing with in our services, is that 70% of the people believe that it's someone such as a close friend or relative that will be contacted in an emergency, and that's okay. 57% felt it was someone who could make healthcare decisions or consent to medical treatment if they were unable to. 54% felt it was someone who could make personal decisions about them if they were unable to. So I think it's important to bear in mind, if we all think of who we would think our next of kin is, who would we want making all of these decisions? Is it our next of kin, or is it someone we would like to nominate? 52% said it was someone who could make a decision about life support treatment for them. 35% said it was the only person to be given medical or personal information about them. And 32% said it was someone who could access their bank accounts and assets if they were unable to. And most of us get very upset about who can access our bank accounts, but we're not at all worried about who's the person who's going to be making life support decisions about us. And in actual fact, that's the really important one, because we won't have the ability to make those decisions ourselves if we're at that point in time. So what does the HSE National Consent Policy say about next of kin? Well, they say that the role of a family is that no other person, such as a family member, friend or carer, and no organisation can refuse consent to a health and social care service on behalf of an adult service user. What does the Medical Council guidelines say? Well, they say if there is no one with legal authority to make decisions on the patient's behalf, then the clinician will have to decide what is in the person's best interest, and in doing so should look at all of those various options. So neither the consent policy nor the medical professional or the professional conduct for registered medical practitioners, none of them give authority to next of kin. So why are we allowing and why are we asking next of kin to sign consent forms? What happens then, and who can consent if a person lacks capacity? Well, the starting point must always be you presume a person has capacity. And a person doesn't have to prove it. You shouldn't be making assumptions about it. And because a person is making an unwise decision, it's not indicative of a person lacking decision-making ability. So the presumption of capacity is to consent, and the decision-making is the presumption of innocence is in criminal law. It's important to bear that in mind. So when it comes to a person having difficulty with their decision-making, it's important in the first instance that they're supported. And we as healthcare workers have a duty to maximise a person's ability to make their own decisions. And as Jacqueline has spoken about, the Act is there to make sure that that happens. But before the Act ever comes into place, we have a responsibility under much of the disability legislation to support people with making decisions. We have a responsibility to ensure that they're given information in a way that will best support them to make the decisions. It's important that when we're looking for a decision to be made, that it's the right place and time, that the person has adequate time and support, and that's using clear English, and Jacqueline has spoken about that, maybe using interpreters if it's required, and simple verbal information and information leaflets. And we've seen that with the vaccination programme, that so much information was produced at short notice to help people in relation to their decision making. And if appropriate, these should be provided to people in advance and giving them the opportunity to have that information and to be able to think about it. So what you're looking at then, if a person is lacking capacity, is about what is the benefit for that person? What is their will and preference? So people are all different, and we're all different in what we want. So you're looking at what matters most to the person, what's their quality of life, looking at minimising pain, getting back to work, reducing risk of future illness or injury, and the length of life. And concerns, looking at the complications, loss of independence, and likelihood of success of a particular intervention. So when you're looking at the will and preference, the most important thing is to ask the person, because sometimes what in actual fact happens, we're asking people to make decisions when they never before have been asked what dress they would like to wear, what they would like to eat for their breakfast. So it's important we, support people with their decision making and give them a choice in everything that they do. If the person can't communicate, then you ask those close to the person, what were their previously expressed wishes and preferences? Is there anything in their healthcare record or any other record that we have available that might help us to find out? A person only lacks capacity to provide or refuse consent to an intervention if she is unable to, as what Jacqueline spoke about, understand the information relevant to the decision. So does the person understand the information relevant to the decision, including refusing? Have they a general understanding of the most important points? Does the person, they don't have to be an expert. None of us are experts, except in a very, very, I suppose, relative field to where we work. Is the person able to retain that information long enough to make a voluntary choice? And it's important to bear in mind, it's not a memory test. The information only needs to be retained for long enough to make the decision. And is the person able to weigh up that information as part of the process, making the decision? And are they able to communicate their decision? And that's in whatever way they normally use to communicate. And that could be talking, writing, sign language, some use of assistive technology, whatever means. So then who has legal authority if the person lacks decision-making capacity? At the moment in practice, almost nobody. If a person is awarded court, then the court committee may have it if the courts have given them authority. If there's a dispute with the committee or it can't be resolved locally, the matter then will have to be referred towards the court, the registrar of the wards of court. And it's important to bear in mind an enduring power of attorney under the current law does not include a healthcare decision. So then if you're looking at people who don't have capacity, this is what the National Advocacy Service use in relation to trying to seek out, or how do you find out what a person's will and preference is. And they use the 4 internationally recognized approaches to ascertain a person's will and preference. And that's looking at person-centeredness, being a witness observer, the rights-based approach, and ordinary life's principles. And they look at what is involved in person-centeredness. And there are things like I've spoken about already in relation to files, records, healthcare records. Does the person have an advanced healthcare directive, or do they have an advanced healthcare plan? Speak to those who are close to the person. These are all common sense things that we all should be doing, but don't always happen. What is the person's values, beliefs? What are their preferences? What are their attitudes? What were their views on other interventions or services that they have had in the past? What are their past behaviours and convictions? Do they have any other cultural, religious, or ethnic factors that might impact on the decision? And consider conflicts of interest, and particularly if there are family members there with maybe strong health views. And that's particularly relevant now in the context of the vaccination programme. And then looking at the witness observer aspect, and that's about what would the impact of the intervention or service, and that's allowing a reasonable accommodation for the person in relation to, let's say, if it was the vaccination, the time, numbing gels and stuff like that. But it could be given them desensitization programs for whatever aspect of care relevant to the intervention. So you'd be observing responses from a person, whether they're walking away, whether they're dissenting, or they're becoming distressed even by the conversation, looking at the body language, etc. These again are all basic common sense approaches. Then from a rights-based aspect, it's about respecting the person's human rights. Everyone has the same right to life, and everyone's life is equal to all others. You have a right to bodily integrity, so you have the right to say yes and no. You also use your freedom principles, and you also look at the HSE consent policy where no next of kin has decision-making authority or assumed authority, because lots of people assume authority as next of kin, and in actual fact, that is not legal authority. And again, you're also looking at the ordinary life domains, and there are the 8 domains that you would all be very familiar with. So what if those close to the person disagree with the decision? Well, most disagreements can be dealt with if adequate communication takes place. So it's important that, because oftentimes if you try and look at why are they disagreeing, do they have the information again? And it again, many times it comes back down to having more time communication with the person involved. So it's important, though, to carefully consider the views of those who disagree. They're closer to the person and maybe know the person best. They may have a better insight into the likely will and preferences of that person. And nobody wants those close to the person to be upset and to cause upset within any trusted relationships that exist. But it's important that you seek to allay concerns and you try to get the bottom of the concerns. And if all else fails, consider involving an independent advocate. And as a last resort, you can go to the courts, but that would be a very last resort. Why do we want to improve the process and why is it necessary? Consent, we know, is treated as a formality with focus on getting the form signed. We know that there are massive time challenges within services. And we know that even after the process, people have limited understanding of the benefits, risks and harm of the proposed treatment, and oftentimes have a poor understanding of the poor outcomes. They also sometimes do not realise that they have the option of refusing and saying no. And if you think about, oftentimes people only have a 15-20 minute outpatient appointment and are expected to make decisions as a result of it. And then how can people make a rational decision as a result of that small time? So what are the benefits of having a quality process for any decision? Well, it supports people to make informed decisions. It strengthens the therapeutic relationship that you have with the person, and it improves the follow-up and aftercare. It engages families and people and those close to them. It also increases their satisfaction with services, and it also avoids cancellation or of interventions. And lastly, it does help prevent litigation. So just to finish on, no man is good enough to govern another man without the other's consent. And it's important to bear that in mind, that we as healthcare professionals, and it's amazing if you all sit back in your practice, or if you ever had anybody in hospital belonging to you, and sit back and look at the number of interventions that actually happen without a reasonable consent process having taken place, the amount of assaults we could be all accused of is quite high actually. So I would just suggest that after today, you all sit back, take a look at what you actually do, and look at the amount of interventions that many of us get involved in where we don't actually really get consent to do so. And that's not about a big formality of consent. It's about even going in to take a person's blood pressure. Do we just go in and take it, or do we explain to it? So thank you. That's all I have to say. And over to you, Cliona.
Thank you, Marie. And again, thanks for the reminder that the assumption of capacity is always going to be our starting point for any of our working relationships with anyone that we're working with. When to get consent and when not to get consent, I have to say I was particularly interested in. So yeah, there's a lot to think about there, and particularly in the context of time per environments that we work in, and the planning that's needed to get consent, and to explore the issues of consent with plenty of time. We did have an issue with the Q&A section, so I just wanted to let you all know that that has been sorted. If you'd like to refresh your page that you're viewing the webinar on, that'll bring up the Q&A section if it's not there already. So please do let us know what your questions are. And next up, we have Patricia Rickard-Clark. Patricia is going to talk about protection of liberty safeguards and place of care decisions. She's the former commissioner of the Law Reform Commission and is chair of Safeguarding Ireland and deputy chair of SAGE Advocacy. So I'll hand over to you now, Patricia. Thank you.
Okay, thank you, Cliona, and good morning, everybody. And I'm very pleased to be talking to the group this morning and to be following both Jacqueline and Marie. So I'm following really on the two themes. First of all, the right to make a decision, and then the need to get consent in relation to any intervention. And I'm concentrating particularly on place of care decisions. And of course, as we all know, if a person lacks capacity, who makes those decisions? And obviously both in the European Court and indeed in the Irish Court have said that professionals, healthcare professionals, do not have any legal authority to become substitute decision makers. So that causes a problem. Marie spoke about the SAGE advocacy Red C poll on next of kin and the high numbers there who misunderstood the role of next of kin or felt next of kin had a role. Safeguarding Ireland did a Red C poll in February of 2020 about place of care decision, and 58% of the Irish population think they can make a decision about a person who is old and frail but has capacity, but can make a decision about their place of care without that person's consent. So we've a lot of work to do to deal with some of those issues. So I'm going to look at, first of all, the human rights obligations, and then talk about the AC case, which was the case that went from the High Court, Court of Appeal, and the Supreme Court on this issue, really, of detention. So first of all, our Constitution specifies that all citizens shall, as human persons, be held equal before the law. And yet we tend to treat people who lack capacity to have different rights. The state then, in its laws, guarantees to respect as far as practical, to defend and vindicate the personal rights of the citizens. Bodily integrity in the healthcare context and right to privacy are key rights in the Constitution. No citizen shall be deprived of his or her personal liberty, save in accordance with law. And our big problem is we do not have adequate, we don't have any actually statute law in relation to place of care decisions as such. The 1996 case in Wards of Court, the court was very clear to say that the loss by an individual of his or her capacity does not result in any discrimination of his or her personal rights recognised by the Constitution, including the right to self-determination, and the rights are in no way lessened or diminished by reason of incapacity. So the fact that a person lacks capacity, they still have full legal capacity and legal rights. And the question is, how are they to exercise those rights if their capacity is at issue? The European Convention of Human Rights, again, everybody has the right to liberty and security of person, and no one shall be deprived of their liberty save in accordance with the procedure prescribed by law. There are exceptions, and we have our criminal law if somebody commits an offence. We have our mental health legislation if a person has a mental disorder and needs to be detained because they're a risk to themselves or another person. Everybody who is deprived of their liberty shall be entitled to take proceedings by which the lawfulness of their detention shall be speedily decided by a court. And then the right to privacy and family life. And of course, where you live is very much your right to privacy and family life as well. Just looking at some of the cases and the points that were taken up by the European Court of Human Rights, the key purpose of Article 5, right to liberty, is to prevent arbitrary and unjustified deprivation of liberty. In order to meet the requirements of lawfulness, detention must be in accordance with the procedure prescribed by law, and it requires fair and proper procedures offering the person concerned sufficient protection against arbitrary deprivation of liberty. So we have to ask ourselves, what procedures have we in relation to putting a person in a nursing home, detaining a person in a hospital with or without capacity? So the requirement of lawfulness is not satisfied merely by compliance with the relevant domestic law. Domestic law itself must be in conformity with the Convention. So really important that we are aware of that. It's the European Convention and indeed the UN Convention, which I'll come on to. Not only must our laws comply with domestic law, but we have that gap at the moment. We must comply with our international human rights obligations. So where deprivation of liberty is concerned, it is particularly important that the general principle of legal certainty is satisfied so that people know exactly that the domestic law is clearly defined and meets the standard of lawfulness. So again, as you see, the gaps that we have currently. The Council of Europe then guide on Article 5. The Article 5 contemplates the physical liberty of the person and ensures that no one is deprived of that liberty in an arbitrary fashion. And again, very importantly, and this is the point that actually we haven't really realised until quite recently, deprivation of liberty is not confined to the classic case of detention following arrest or conviction, but may take numerous forms. For example, placement in social care institutions. The right to liberty is too important in a democratic society for a person to lose the benefit of the convention protection, especially when that person is legally incapable of consenting to or disagreeing with the proposed action. That the fact that a person lacks capacity does not necessarily mean that he or she is unable to understand and consent to a proposed action. There are a number of cases before the European Court where they looked at, with support again and assistance, a person could decipher the information and could actually consent or refuse the proposed place of care. So really important that we take that time to assess whether the person is in a position to make a decision. Obviously, even measures intended for the protection. And again, we hear that the person is going to fall, they're at risk, there are no facilities at home, etc. So what the European Court said, and I'll come to the AC case again, even measures intended for protection or taken in the interest of the person concerned may be regarded as deprivation of liberty. So again, there are general principles set down by the European Court of Human Rights. What would be the deprivation of liberty for a non-disabled person is also deprivation for a disabled person. So really important, the person's compliance or lack of objection, the relative normality of the placement, and the purpose behind it are all irrelevant to this objective question. And there was the case in the UK where Lady Hale in the Supreme Court was dealing with a case where the argument was that the two sisters were in a very, very good luxury care home. And she said, a gilded cage is still a cage, and they were detained and they lacked capacity. So gave rise to quite a number of issues in the UK that had to revise their protection of liberty safeguards rules. So we incorporated 2003 European Convention of Human Rights Act and provided in that act that Irish courts must interpret Irish law in a way which gives effect to the state's obligations under the European Convention, regardless of whether that legislation is pre or post 2003. So if you take our Wards of Court legislation of 1871, we should be interpreting that in accordance with our Human Rights Act and indeed in accordance with the ECHR, which we have not done. It's only recently the court itself actually has been raising issues of rights in relation to wards. Every organ of state must perform its function in a manner compatible with the state's obligation. HSE, all service providers, all health care providers must perform its functions in accordance to be compatible with the European Convention. In relation to the courts, judicial notice must be taken of any declaration, decision, advisory opinion or judgment of the European Court of Human Rights. And again, in spite of all of those cases coming before the European Court of Human Rights in relation to deprivation of liberty cases, we tend to have ignored many of those. And of course, many of our cases have not reached our courts for the simple reason we didn't have a right to legal aid for people who lacked capacity, which again is a huge deficit. Moving on then to the UN Convention on the Rights of Persons with Disabilities. Again, state parties shall ensure that all persons with disabilities are treated on an equal basis with others, enjoy the right to liberty and security of person, are not deprived of their liberty unlawfully or arbitrarily, and any deprivation of liberty is in conformance with law. And again, state parties shall ensure that if persons with disabilities are deprived of their liberty through any process, they are on an equal basis with all others and entitled to the same guarantees the international human rights law. So really important that we have regard to both the ECHR and the UNCRPD. Article 14 then, the UN Committee of the UN made comments in relation to Article 14 and pointed out that the committee reaffirms that liberty and security of person is one of the most precious rights to which everyone is entitled. state parties should refrain from the practice of denying legal capacity of persons with disabilities and detaining them in institutions against their will, either without the free and informed consent of the persons concerned or with the consent of a substitute decision maker, as this practice constitutes arbitrary deprivation of liberty and violates Article 12 of the Convention. The General Assembly report, again commenting on Article 14, reaffirmed the right of liberty and security of person and stipulates that persons with disability cannot be deprived of their liberty unlawfully and arbitrarily, and clarifies that disability shall in no case justify a deprivation of liberty. States parties have an obligation with immediate effect to refrain from engaging in any action that unlawfully or arbitrarily interferes with the right to liberty and from authorising such practices, and protects this right against practices by private actors such as healthcare professionals and providers of housing and social services, and takes positive action to facilitate the exercise of the right of liberty. So again, that's 2019. And what have we done here in Ireland to comply now that we ratify the UN Convention in 2018? So states have an obligation to immediately repeal all legislation that allows for deprivation of liberty on the basis of actual or perceived impairment, whether in public or private settings. Unfortunately, our problem is we don't have any legislation to repeal in relation to place of care. We certainly have legislation to repeal in relation to wards of court situation. But again, we need a procedure prescribed by law. And just then, the UN Special Rapporteur had points to make as well. So again, pointing out that institutionalization is a widespread form of deprivation of liberty. So we have to bear that in mind. We did not think about this in the past, that congregated settings, etc., were forms of deprivation of liberty if people were not there with their full consent. So many people are living in institutions without their consent and without the opportunity to challenge their placement. And again, we have no procedure where a person says they do not want to be there, but automatically they get legal aid to apply to the court to have a determination of whether they are being detained legally or not, or in an arbitrary manner. So again, there are examples there: lack of choice over whom to live with, identical activities in the same place for a group of persons. These are all institutionalization, a paternalistic approach in service provision and living arrangements, supervision of living arrangements. So I'm moving on then to the AC case, Cork University Hospital case, which very challenging case in terms of the family dynamics. The lady, Mrs. C, was taken into wardship. A wardship order was made that she be detained. First of all, she was detained in the hospital, and then the decision to put her into a nursing home. So her son, Mr. AC, who was a difficult person to deal with, made an application, appealed the wardship order to the Court of Appeal. And the application was made, interestingly enough, under the Constitution, not raising either the ECHR or indeed the UN Convention. So the Court of Appeal, Mr. Justice Hogan, said that this raises legal and constitutional issues of far-reaching importance regarding the personal liberty, not least insofar as the care and welfare of the infirm and elderly are concerned. It is a right under the Constitution, and it cannot be swept away by Victorian wardship legislation. This is a legal issue, it is not a medical issue. Article 44.1 provides that all detention must be in accordance with law. Again, importantly, the reasons and motives of the detainer are not relevant to any consideration of this issue of law. So the question then was whether the detention was lawful. The power, and this is again Mr. Justice Hogan in the Court of Appeal, the power to detain claimed by the hospital amounts to a paternalistic entitlement to act in the best interests of the patients whose capacity is impaired, and in effect to restrain their personal liberty and freedom of movement, and if necessary to do so at the expense of close family members. But ever before, the Constitution, the common law, has always rejected the claim that personal liberty could be compromised on any basis. So again, the fact that we lack legislation in relation to this, the Constitution and the common law applies, just like we have the presumption of capacity in the common law, etc. So really important points, though, made by the Court of Appeal. In the question of whether the detention was lawful, the Court said, while one can certainly sympathise with the position of Cork University Hospital, their self-created power of detention might, if unchecked, lead to widespread abuse. For if the power of detention claimed by Cork University Hospital was to be judicially accepted, the logical consequence would be that tens of thousands of the infirm elderly who are suffering from dementia or whose capacity is otherwise impaired and who are presently residing in nursing homes and other similar institutions could equally be restrained from leaving. In many cases, this would doubtless be for good clinical reasons. In other instances, however, this decision could be simply for reasons of convenience and perhaps in a small minority of cases for even less noble motives. Now, obviously, the Court of Appeal decided that she was unlawfully detained, and then there was an appeal to the Supreme Court by the HSE, arguing that her detention, she was not detained, or that her detention was lawful. Again, the Supreme Court, and I think it's useful to quote what the court said because it really hones in on the particular issues. So I consider that the constitutional guarantee of the right of liberty protects mentally impaired persons to the same extent as everybody else. Deprivation of liberty must in all cases be in accordance with law. To hold that persons cannot be found to be detained if they are not capable of making a valid decision to leave for themselves, or if they are not aware of or able to object to that situation, would not simply permit restrictions on their freedom of movement for their own protection. In other words, the HSE was arguing this lady lacked capacity. She was unable to make that decision. They had to protect her. The court goes on to say it would also have far-reaching consequences if that was the situation of denying to vulnerable persons the benefit of the constitutional guarantee that they will not be deprived of liberty otherwise than in accordance with law. It is possible for a person of full capacity to be detained without necessarily being conscious of that situation, and equally it is possible in the case of a person being with impaired capacity, both are entitled to legal protection. The court went on to say that for the same reason, again, a benevolent or protective motivation or purpose for whatever measures have been taken cannot be considered to alter the legal fact of detention. So the fact you're concerned about the risk, you're acting in the best interest, etc., does not alter the legal issue of detention, legal fact of detention. If benevolent intentions meant that there was no deprivation of liberty and therefore no grounds for inquiry into the legality of deprivation of liberty, there would be no legal basis upon which the courts could ask whether the measures taken were justified and were in fact in the individual's best interests. This would in fact leave vulnerable people without legal protection against arbitrary or unnecessary detention. The persons or institution that take charge of them would there appoint themselves as a substitute decision maker without a legal process. And again, the Supreme Court referred to the European Convention of Human Rights and pointed out that neither the European Convention nor the Constitution would permit or permits such a result. So very clear messages there in relation to detention. Now, again, what the court found, in fact, that Mrs. C was detained, but actually that she was lawfully detained in the particular circumstances. And it set out and found, first of all, that the High Court, in making the decision to detain her, predetermined that she lacked capacity, and the Supreme Court sent the case back for a further hearing as to her capacity in the High Court, and pointed out, and again, as I said, this was quite a challenging and contentious case all along between healthcare professionals, family members or whatever, but the Supreme Court pointed out that the most striking feature of all the litigation and of all the court-mandated procedures to date is that it proceeded to the point on the basis of arguments between third parties and decisions of courts as to what Mrs. C wants and to what was in her best interest without her voice being heard. The Supreme Court was very critical of the fact no independent advocate, she wasn't there, wasn't present. Now, under our 2015 Act, people will be present in court insofar as that's possible, but it'll be the exception that they will not be in court. Also, their voice must be heard in some form. And again, the 2015 Act does have mechanism in place to deal with that. So what is the action now? So if the hospital is concerned that the patient lacks capacity to make the decision, then obviously it must be referred to the court. So if she lacks capacity, the hospital must bear in mind that it has no general power of detention and no general right to make itself a substitute decision maker. It therefore must seek the assistance of the court if it is felt that the patient is at risk. Now, that comes back to the pre-planning, appointing somebody, doing your place of care decision, either in your EPA or in your advanced healthcare directive. Really, really important to have somebody there to make that decision. Then the Supreme Court decided that the doctrine of necessity in that particular case permits the hospital to detain the person in the interest of personal safety, provided that such detention lasts no longer than is necessary to take appropriate steps. It also said the application to court in such cases, it must be, first of all, a last resort. Every effort must be made to find out and get the consent of the person if possible. And any application must be made speedily within less than 2 weeks to the court. And then where she is detained, it must be obviously very speedily. So where are we? We had a draft bill on protection of liberty safeguards in 2017. That went for public consultation. And again, various different provisions in that bill really was providing for detention in designated centres or whatever, but obviously now that the legislation has to be extended to include all acute hospitals as well. And under the current legislative programme for government, the Department of Health, we will see new protection of liberty safeguard legislation, but we haven't a timetable for that. So that's disappointing, but we have that real gap that we have to. So again, the philosophy and legal processes required, the presumption of capacity, support to the person, functional approach, independent advocate, independent of the family service provider and systems interest. And again, the fundamental first steps assess the care needs, the treatment required, whether the needs can be met in the current circumstances, the risk to the person and the choice to the person. And again, in that application to court, they're the issues that the court will be looking at as to have those fundamental first steps being taken. So in conclusion, to say the right of liberty is too important in a democratic society, and I'm quoting from the European Court, for a person to lose the benefit of convention protection, especially when that person is legally incapable of consenting to or disagreeing with the proposed action. So legislation obviously must be formulated to comply with the Constitution and the state's international human rights obligations. In the current practical situation, which is very challenging at the moment, without procedures, without legislation, there is an urgency for that legislation. So we should be all actually shouting and making sure that the Oireachtas are aware of the gaps that are there. And I can't emphasise enough then planning in advance, place of care decision. Again, to ask those questions at a very early stage, rather than wait at the end when a decision has to be taken that this person has to be detained or go somewhere or put into a place of care. At the very first meeting you have with a person who is ill, maybe have those conversations and continue those conversations throughout their care journey. So many thanks.
Thank you, Patricia. You've made a very clear case there for the need for urgent legislation in this area. And we have had a couple of questions come in that we'll go to at the panel discussion. So I'm going to go straight over to Amanda Casey, who is the head social worker in the matter, and she's going to talk about the implications of the Act for social work. Thanks, Amanda. Amanda has been working in the matter since 2014, and she's been involved at a strategic level there in the development of hospital-wide services for acute medicine, inclusion health, frailty, and home first initiatives. Amanda has a strong interest in ensuring the voice of older persons is heard both in healthcare settings and at a wider policy level. Having the perspective of the reflections from practice is a really helpful perspective for us to have here, and particularly with us leading into the Q&A, because how we implement the Act and the spirit of the Act in our practice is key. So over to Amanda, thank you.
Thanks, Cliona, and thank you also to Jacqueline, to Mary and to Patricia for really valuable presentations. I think every time I think I understand the process that we're all going through, and then I hear or listen to a presentation, and I suppose I hear something new, and I think that can sometimes feel a little bit overwhelming for us. So I think these sorts of sessions are really, really useful, and I think we probably learn as much, if not more, from the Q&A sessions and from each other. So I will go through the presentation quite briefly to give us some time then at the end. So as Cliona mentioned, I've been asked to talk a little about the potential implications of the Act from an acute hospital perspective. Cliona was very kind, saying I've only worked here since 2014. I've worked here way longer, sadly, but anyway. So I think traditionally Ireland has relied heavily on inpatient and acute medical settings for health delivery. And I think that's been reinforced by the often disproportionate funding mechanisms that are put in place for social care services. I think what that has essentially led to is that people have had to access acute services in order to eventually access community services. Now, I'm hopeful certainly that the implementation of Sláinte Care will go some way to redressing this balance and lead to an increase in both care delivery and decision making taking place as close to home as possible. But the reality at the moment is that for many people, major life decisions continue to be made at times of crisis, and consequently often in the inappropriate setting of an acute hospital. A hospital admission often precipitates either entry into the social care system or in some cases into the residential care system. And I have significant concerns that this doesn't always support the individual to become and remain meaningfully involved in decisions about their future. I'm going to the next slide there, sorry. Oh, I knew we'd run into difficulties technically. I'm pressing my return button here and nothing is happening. Yeah, no, unfortunately that's not working either. Yeah. No, I wonder, are you able to move it on for me? Hang on. I might stop share and go again if that's okay. Apologies to everybody for this. Yeah, okay. Now let's see if this works. Okay, this is going to work better, I think. Okay. So I'm going to start talk initially about the challenges, I suppose, as I experience them and understand them. And I'll use some case examples along the way if that helps. I'm also going to draw on two pieces of research that were carried out over the last number of years collaboratively by the School of Social Work, Social Policy and Social Justice and the School of Nursing, Midwifery and Health Sciences in UCD, which demonstrates some of the concerns that healthcare professionals have already raised when considering the implementation of the Act in various health settings. And I will provide the links to the articles for Cliona at the end if anybody would like to read them at their leisure. The first and most obvious challenge to meaningfully supporting someone to make decisions is the physical environment of a hospital. Very often it's overcrowded, it's noisy, it's bright day and night, and there are people coming and going all hours of the day and night. There's limited privacy in many settings, and to facilitate conversations and staff patterns often mean that patients don't get the opportunity to develop a rapport or a relationship with any one person. And I think that leads to them often not being able to be heard or understood. I think the other challenge, which is worth noting, is the unscheduled care context that most hospitals operate in. Unscheduled care, which represents over 80% of hospital activity in Ireland, is by its very nature messy and it's unpredictable. And care decisions are often based on the demand for beds as opposed to the individual needs of the patient. And the constant need for flow means that the time and space needed to assess decision-making capacity and to support the outcomes of those decisions is very, very difficult to secure. I think the second and perhaps more embedded challenge is culture. I think Irish culture has traditionally been very deferential to the professions, to the GP, the parish priest, the solicitor. These are people who would have all held great standing in the community and would have been relied on quite heavily for decision making. And these views have served to support a very traditional medical model in many hospitals. Now, I think there are a lot of hospitals that have moved very firmly towards a more inclusive MDT approach. But I would still posit that there remains a pervasive medical model where many decisions are professionalised and they are pathologized. And I think I've had a couple of recent experiences that I'll share with you, which I think demonstrates to me that we still have a long way to go. I think the case that was referenced recently is a prime example of that. But for example, I recently was involved with a gentleman who had been admitted to the hospital and had been living for over 40 years in various kinds of institutional care. And he was most recently living in a kind of a high support mental health hostel, where he was really well known and well established and had a good support service around him. And he was admitted to the hospital here, and a decision was made that he required potentially life-saving, but also potentially highly risky surgery. And obviously, again, and Patricia referenced it there around the time, and and Marie talked about it as well, about often the urgency of decision making and how that is sometimes used as an excuse maybe to leave behind the principles that we all understood need to be followed. And essentially, what happened in this case was, no one thought to ask the team who were working and had been working with this man what his will and preference might be, what if they'd ever had discussions with him about what he might like to happen next. And immediately I got a call because we were suddenly going to the High Court to get an order to do surgery. And again, it was that there was just this kind of, again, because of the urgency and around the decision, we completely forgot the principles that we needed to make. And interestingly enough, when they went to look for the capacity reports, and again, this is sort of, I suppose, that the hierarchical thing, the gold standard is seen to be a psychiatrist in terms of an assessment of capacity. And initially, that person may have only met the individual once for 20 minutes and done a capacity assessment and made a call on it. A geriatrician is considered to be kind of slightly lower down the pecking order. But at no point did anybody think to ask the team of nursing and care staff who had been looking after this gentleman, since his admission. At no point had they asked the social worker who had actually completed a comprehensive assessment in terms of what his strengths, what his concerns were. Those views weren't sought. So I think for me, and certainly in hospitals, we have quite a way to go. Now, without being overly negative about it, I suppose I'd like to then talk about the strengths in terms of social work and what social work can bring to the table. And I'm going to read a quote from the IASW advocacy statement, which I think is a really good starting point for a discussion on what we can bring to the table. We do not sit on the sidelines observing the lived experience of the adults, children, and communities we work with. We are active on their behalf, taking a stand for and with those who are marginalised, disadvantaged, at risk, and not heard. We speak up for social justice. We demand the change needed to tackle the inequality we experience every day and the resources to make that change happen. It's worth bearing in mind that social work are the only registered health and social care professional with expertise in human rights training, with socio-legal expertise and challenging of systemic social injustice. So we are well placed, I think, to be able to look at a systemic view of all of the issues that are contributing to this. In my own context in the hospital, one of our key skills is using crisis intervention theory to quickly develop a rapport and a relationship with our patients. And we are used to working at the interface of policy and practice, and we are often some of the first professions who understand and see from the individual's perspective the impact that an external decision has had on their personal lives. And we have lots of experience of working in the grey. Often, certainly in hospitals, the social worker gets called when people have run out of ideas as what to do next, and it's kind of messy and there's no clear right or wrong in this, and the social worker gets brought in. So we are experiencing working in the grey. I think just in terms of a couple of case examples, I just said I'd use an image there. I think I think it's impossible to avoid the links and the interdependency of the Assisted Decision Making Act and other policy and legislation, such as safeguarding, such as consent, the Deprivation of Liberty, the Withholding of Information Act. And these complex issues are going to require time and space and a lot of collaboration, I feel, to tease them out. A couple of examples. The image on the left is probably a very extreme example, but again, we see this regularly in varying forms. This was an individual who had been admitted to the hospital from home with a respiratory tract infection, so no major serious illness going on. They had limited engagement with community services. There were concerns raised by neighbours, obviously, and by the public health nurse, by the GP and their family about this individual's ability and to manage at home. The individual himself had a very, very clear preference to return home despite all of the concerns and repeated admissions. And this person would have been admitted probably once every 6 weeks for, a little bit of teeing up again and back out. So this was a kind of a pattern that was repeating itself over time. Now, I think their ability to engage and their interest to engage in assessment and discussion fluctuated from day to day. But overall, there was quite a clear consensus that this individual had the ability to make a decision about where they wanted to live and what they wanted to happen after their hospital stay was over. It was a really challenging environment for us because, with advocacy comes responsibility, I suppose, and we have to listen to and respect the often very genuine concerns of those involved in caring for someone in those kinds of situations. The neighbours were rightly concerned of fire. And this was an individual who lived in a flat complex. So there were people above, below, on either side of them. And there was obviously, as you can see from the photo, a huge amount of rubbish and papers lying around the place. The individual was a smoker. And obviously there were huge concerns about the implication for other people of this person's decisions and their right to make decisions about their care. I think the second image is representative of the more frequent scenario. And I think just, Patricia, I was struck when you were speaking there about the deprivation of liberty and the image of a closed door versus an open door. And interestingly, hospital wards now, particularly in the advent of COVID, are locked. They're closed from an infection prevention and control point of view. But I think the very image of a hospital door not being open gives a very, very strong message to the individuals on the inside of that ward that they are not free to move about as they might wish to. I think, the people who are admitted to hospital often become lost in the system in terms of the decisions about their care. The structures within hospitals are designed to disempower in some ways. The person is in bed, they're in their pajamas, they're discouraged from moving around, they're isolated from their support systems. During COVID, this has become even more exacerbated because visitors aren't able to visit and to do that piece that's so significant in terms of being the voice of the individual. And so in many ways, they have become more invisible than they might always have been. And I think, as was already referenced there, this is amplified by the continued reliance on structures like next of kin, which suggests a legal authority or decision-making status, which has no legal basis. And I think even the fact that that is still used in official hospital records is something that we really need to change. So I think we do have a significant way to go. However, where do we go from here? And I think sometimes, and as I said at the beginning of my presentation, sometimes when I hear these, I feel a little bit overwhelmed. I think, oh, there's so much we need to change. There's so much we need to do. And I was struck by the image of that huge carrier in the Suez Canal in terms of how do we even begin to make it. But I think the image of the little digger at the side slowly taking it away bit by bit, it was actually a really positive one because it's that bit by bit. And I think this is where we as practitioners come in. And for me, the most important piece here is that language matters and our words have power. And I'm going to refer to an article again. I can give the link to Cliona in the Journal of Age and Aging entitled Not Safe for Discharge, Words, Values and Person-Centred Care. And it really highlights the importance of language and the language that we use in both shaping our perspective and the perspective and behaviours of others around us. I think other terms which are often seen and heard around hospitals and sometimes make me very cross are things like not back to baseline, or they're a falls risk, or the catch-all, they're vulnerable. And I just think that it is incumbent on all of us who are delivering any kind of services to respectfully challenge colleagues who use risk-averse practices and language like that. And now is the time to do it. I think, what can we do now? We can start modelling the principles of the Act. They're there. They're something that fit very well, I think, with social work in terms of our own values and ethics. And I think we can start using the terms, use the term decision-making capacity, both orally and in our written records. We start to talk about it and break those things down. And if they are there, they are slowly influencing those around us. I think we need to encourage conversations about advanced care planning in all settings. And I know there are social workers here from across the different spheres, in terms of primary care, mental health. We all have opportunities probably on a daily basis to have those conversations or to introduce those conversations. And I think, again, it's about using those opportunities, those teachable moments, to introduce those concepts to the patients that we work with, to their families, and to our colleagues. I think, I'll finish by saying that I think the Act can and will support social workers to work in a person-centred way, which upholds our core code of professional conduct and ethics. And I think it starts small, as I said. Find one or two colleagues who are like-minded, or have a conversation with them. It's about that sort of, if we start every day to embrace the Act in terms of its principles and its language, then I think when the other pieces of support come in, it will be easier for us to make that move. Thank you very much for your time.
Thank you, Amanda. We've had quite a few questions coming in, and I think because we have about just over 10 minutes left, I think it'd be a good idea to just move straight into the questions. One question was sent in to us by some of our members here in the association. So it's a little bit lengthy, and what I'd like to do is just to read through it for the panel, and then whoever would like to start unpicking or offering some guidance in relation to that question would be really helpful. I suppose the question really concerns how best to work within the spirit of the Act, as Amanda has referred to and spoken about, but while working in the context of other policies and legislation. So the members were seeking advice in relation to consent to report safeguarding incidents to the HSE and/or the Gardaí against the expressed wishes of a client. The issue is arising in cases where a client is considered a vulnerable adult under the Safeguarding of Vulnerable Adults at Risk of Abuse Policy 2014, will have capacity to make decisions in relation to whom they wish to be informed. These are cases which do not meet the criteria for reporting under the Criminal Justice Withholding of Information Act 2012. Some people with disabilities about whom safeguarding concerns have arisen have specifically stated they do not want their personal information shared with the local safeguarding office, though they are happy to be involved in a safeguarding plan to keep them safe. As social workers, our clear professional responsibility is to support the person to make themselves safe, to inform them of their options, including reporting matters to adult safeguarding and Gardaí where appropriate. Acting against a client's expressed wishes, however, particularly regarding less serious incidents, appears to be in breach of our professional code of ethics, as well as the UN Convention on the Rights of People with Disabilities and the spirit of the Assisted Decision-Making Act. Social workers can feel pressure to report these matters, including giving the victim's personal details to comply with the National Safeguarding Policy. The Withholding of Information Act has been quoted as overriding the person's wishes, although the incidents are not Schedule 2 offences, and the Act specifically mentions defences for not reporting in Section 4 of the Act. So I know that's a lot of information and a lot of complexity because the issues are complex, but if the panel have any comments or guidance to offer in relation to how best to respond to these issues that are continuing to present, it would be very much appreciated.
Will I hop in?
Please. Yeah.
I suppose to say, first of all, of course, there are very few rights that are absolute rights. So even if we have a right to certain things, there are exceptions, even in the Constitution, the ECHR and the UN Convention. So first of all, to bear that in mind. Secondly, in relation to the criminal law, withholding of information, that created, I suppose, an offence if you were not disclosing information where there were serious offences being committed, including sexual offences, in relation to children and vulnerable adults. So that's really making it an offence not to disclose. It's not say that you have not got a duty if an offence is committed to report. So there's also the Criminal Justice Act of 2011, and Section 19 of that Act also points out that a person shall be guilty. Now, this is generally, this is not confined to vulnerable adults or children. This is generally. So a person shall be guilty of an offence if he or she has information which he or she knows or believes might be of material assistance in preventing the commission of by any other person of a relevant offence. And the relevant offence, there's quite a long list of what is defined in the Act. Or also of securing the apprehension, prosecution or conviction of any other person for the relevant offence, and fails without reasonable excuse to disclose that information as soon as it is practical to do so to a member of An Garda Síochána. So that's the criminal law. There's also, of course, the Non-Fatal Offences Against the Person Act as well, which lists a number of serious offences like assault, threats to kill, or cause serious harm, coercion, harassment, or endangerment to a person. So they're all crimes that should be reported to An Garda. And the issue then coming back, I suppose, in terms of the persons saying, I do not wish that information to be disclosed or my personal information not to be disclosed. So I think there should be a very clear policy in particular situations. So under GDPR then, which is the right to the protection of our information, Article 6 provides, but consent is only one of different issues. So if, say, the HSE as a service provider is actually acting and has as its function, exercising their official authority, they can provide in their policy reporting obligations in certain circumstances. Under Article 9, and again, where a person lacks capacity, there's very clear indication that information can be shared. Now, one of our, again, difficulties is we have both the Data Protection Act of 2018, which sets out, in other words, it gives effect to the General Data Protection Regulation of the European Commission. And it sets out, you must have a legal measure to disclose and share information. Our 2018 Act is drafted, and it requires regulations to set out the circumstances that when it's in the public interest to share or when it's in the substantial public interest to share. We still have a gap there in relation to that. We have our Data Sharing and Governance Act of 2019, where public bodies can share and enter into data sharing arrangements. Now, again, unfortunately, that Act talks about sharing information for the management of public information, but doesn't go into the safeguarding. And when those two pieces of data sharing legislation were being drafted, we did not have, and we still do not have, safeguarding legislation. So if you compare our legislation with English legislation, the English legislation, they have their Care Act, Scotland have their Protection of Vulnerable Persons Act, and when they drafted their equivalent of their 218 Act, Data Protection Act, they included the obligations under their safeguarding legislation. So we need our safeguarding legislation for all of those reasons, to have our detailed regulations, to have our policy set out when it's in the public interest, when we can share. When we're interacting with a person, then obviously she doesn't want her, or he or she doesn't want their personal information shared with other, say, protection teams or whatever. But the question is, should the person be passing that information to the Gardaí? And that's where we need very clear policy around that. So we have to be very clear of our overarching obligation to protect people as well. Safeguarding legislation, people at risk. So when we have that safeguarding legislation, the Law Reform Commission, as you know, is working on a report at the moment in relation to that. So we have huge gaps all along the way, but our overarching duty is to protect a person insofar as we can, to protect and safeguard their identity, but in some circumstances, we've an obligation to report to the Gardaí.
Thank you, Patricia. Much appreciated for your very comprehensive answer. I have another question here, possibly for Jacqueline. With regard to assisted decision-making and capacity assessments, how is the process documented? Are there standardized formats for recording across services? The person asking the question has recently moved from the UK, where they were undertaking Mental Capacity Act assessments. They were saying that social workers have extensive training to undertake this role, and it's a key aspect of adult social work. However, there seem to be many issues around assessments undertaken in health settings where training and documentation is less comprehensive due to other demands. So I don't know who'd like to come in that, perhaps Amanda as well.
Well, I can start. Obviously, kind of the functional assessment of capacity is built into common law. And the way that when you carry it out, it should be kind of very clearly documented in the patient's notes. That's the kind of the documentation piece. There is no form. And I think, I don't know much about kind of England and Wales, but I think they have a fairly clearly set out form. But with the functional approach here, there is no form. And from our discussions with the Decision Support Service and the work that we've been doing, as far as I'm aware, there will not be a form. So all of it's going to come down to how well the process is documented within the person's notes. Are you wanting to come in, Amanda, as well, or Marie?
Yeah, I mean, I think the issue with notes, I suppose, is it existed pre and will continue to exist, I think, post that particular type of assessment. I think, again, without an EP or an electronic patient record that's accessible, I think there is still huge variation going on in terms of how and where discussions of any kind are actually recorded in my case, in medical charts, I'm sure across all agencies. So that in and of itself creates a difficulty. I imagine will have to happen is that individual organizations will have to, kind of come up with some kind of template to try and record it and have it there. But again, I think that's something that necessarily we would need to go maybe to the Decision Support Office or to yourselves to seek guidance on in terms of what would be best practice around recording those kinds of decisions, because I live in fear when I open a medical chart and I just see lots and lots of information and then 4 LTC is written there, and there is absolutely no documentation about, a long care, how that decision was made, who was there, who contributed to it. So I think we have a long way to go.
Thank you. We've another question here on wards of court. Denise Miley is asking, when an application for ward of court has been made by a family member and the patient does not agree with this, what supports are there to support him following the serving of the ward of court order? So I'm assuming that the supports relate to the patient, but perhaps they refer to the family member also.
Sorry, if a family, sorry, shall I?
Go ahead.
An application. If the person is objecting to that application to wardship, it's their voice that counts. And they should be, one, insofar as possible, to try and get legal aid. There's no bar on legal aid if they can't afford a lawyer, alternatively a lawyer to support them, and an independent, or first of all, maybe an independent advocate. Really important, an independent advocate. So again, whoever is assessing the capacity the application has to be supported by an assessment of capacity. So who's assessing their capacity? How are they assessing it? If the person doesn't want to be made a ward of court, have the capacity to make that decision that they don't want to be. So really, really important. But also to point out to the court that the person is objecting to the application in that assessment. And again, interesting again, under the 1871 Act, it's person is of unsound mind and unable to manage their affairs. And in fact, this was an issue picked up by the Supreme Court. And sending back the case to the High Court for the assessment of her capacity, the Supreme Court said that healthcare staff were communicating with her by telephone and otherwise in certain issues. And they said it was issue specific. So was there a conversation with her about understanding the risks of being discharged from hospital? So it was really, really important. So even in current wardship, I would say, what is the decision to be made? And does the person lack capacity to make that decision? Wardship is an all-embracing, as Jacqueline said at the moment. But actually, I think the court itself is now going to be arguing against, sorry.
Okay, Patricia the connection seems to have frozen there. But there's one very short question. It's linked, asking for a list of independent advocacy services or groups and recommendations regarding that. That's something that I can put up on the website, on the event page after this event, if you'd like to send on links. And I can also put up links as well to some of the resources that Jacqueline, Marie and Amanda referred to as well. The speakers can email me those links and I can put them up there if people want to check back on the page. That would be great. And
Clean, also just in relation to the wardship question there is guidance being developed currently at the moment, which should be out in the next few months in relation to wardship applications, which may help in situations.
Thank you. Are we able to go back to Patricia now?
Yeah. Sorry about that. Also, actually, I have a big question, which is a really extremely important question. If the papers are being served on that person who's the subject of the application to wardship? If you look at the rules in the UK, very detailed rules about how that should be done. Here, we tend to let a solicitor or somebody else do it. That is inappropriate. It is really important that the person is fully supported, again, maybe by an independent advocate, particularly if family members are of a different view or whatever, or a social worker or whatever, and that when the papers are being served, there's full explanation given to the person and they're assisted to try and understand if they can understand, but certainly support should be there for that person. So we have a lot of, I suppose, gaps, deficits in our current system. Just back to one of the previous questions about assessing capacity. The first question should be, in any template, why is this assessment necessary? What is it needed for? What is the decision to be made? And then every assessment must be different for the simple reason you have to look at the circumstances of that person and the context in which that decision has to be made. So really, really important. So that's why there can't be a template. So, two 80-year-olds being discharged from hospital, totally different circumstances, financially, resources, family background, everything. They're two 80-year-olds with dementia, but their circumstances and the context in which they live is entirely different. So under wardship, there are two people with dementia straight off to wardship, okay? The new Act, each have their own individual rights, each have their own values, their wills and preferences, really important. So that's why we can't have a template.
Thank you, Patricia. You want to come in there, Marie?
The other piece to the wardship is that oftentimes patients are in a hospital, the staff aren't aware of the various implications and the processes that are going on in the background. And particularly if you have coercive families of and solicitors acting on behalf of families. The papers are being served on the main hospital. The families are using the papers, and the person themselves don't actually get to hold and to read what's there. So that's why it's really important, if you can at all, to use an independent advocate at times like that. And just to have all staff aware of the processes that are going on, because oftentimes this is going on in the background and nursing staff have no comprehension of what's going on at all.
I would say that just certainly in the larger hospitals that would have established social work departments, social work professionals would be very involved in those kinds of scenarios, and would certainly be seeking to ensure that the patient's voice, if an independent advocate outside of the organisation is required, that's put in place. But equally, just ensuring that the processes are happening in a way that is respectful of the individual circumstances.
And that's a very good point. The difficulty, the big challenge is there are lots of hospitals that don't even have a social worker,
Yeah. That's another day's work, Mary.
It is. And I'm afraid we've really run out of time now. We've run over by a good bit. I think that the really strong message that's coming out today is in relation to the assumption of capacity in the first instance. And again, that mantra, really, nothing about me without me. Is there anything that any of you would like to add before we wrap up today?
The pre-planning, absolutely vitally important. And everybody that's attending this is in a very clear position to prompt people to do that. Really, really important. And to appoint a suitable person.
Yeah. And just to say, in terms of the role of our office, we're here to help and to support you in terms of preparing and getting ready for the Act. As I said, we are developing e-learning programs, but we're also happy to kind of come and talk to your multidisciplinary teams or the teams that you happen to work on and give information and briefing sessions similar to this, and we can tailor them to what your needs are. So we'd be more than happy to kind of work with you in the future, because we have a year, and I think that's the kind of, there's just over a year that we have now in order to get ready and prepared for the Act commencing. So, and while I think that yes, the Act might get commenced, there will be a time period after it where we're not fully ready for it, but there's a lot of stuff we can do in advance to help us to get ready for when the Act is commenced in June 2022.
Thank you. And as part of that getting ready, as I said, I'll upload links to resources that the speakers would send on to me, and any of the speaker presentations, once I have permission, I'll upload them to the event page as well. I'd also urge you to check out the submissions and representation section on isw.ie to see the advocacy and lobbying work, the speaking up work the ISW members have done on behalf of the people that we work with and with the people that we work with. And just to finally, to thank all of the speakers for their time and their input and their guidance in the Q&A session. Apologies to those questions that we didn't get to. And finally, I'd like to say a very big word of thanks to Jacqueline Grogan, who did amazing work on putting this together, and I very much appreciate it. Thank you very much.
Thank you.